Welcome to today's program titled 2025 Peculiarities, How California Employment Law is Different. At this time, all participants are in a listen-only mode. For those of you who are logged in for the live web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down as it will not be reread and is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received yesterday afternoon. Copies of the webinar recording and materials will be distributed to all attendees within a day or two following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Chelsea Hoffman. Please go ahead.
Thank you so much, Andrew, and thank all of y'all for being willing to spend a little bit of your day and your holiday season with us. We're very pleased to be today. My partners, Christina Lonnie in our Sacramento office and Daniel Huang in our LA Century City office. So we've got all the corners of California represented today to talk through California peculiarities and how California is different. Now, many of you who have been working in California for a number of years know that we have always been on the forefront of what's new and notable and different when compared to federal law and the law in a lot of other states. And we, as a firm, had decided many moons ago, we realized it was about 25 years ago, the first time we published this Cal Peculiarities book. And we're not even going to make y'all wait until the end of the presentation to get your freebie. We're going to go ahead and give you the link to be able to download it right now. But when this book was born, California really was incredibly different when you compared it to other states, and was one of the only states that needed its own publication on why it is so different and how do you have a business in California. And we know over the last couple of decades, we've seen a lot of states try to compete with California. We have Mass PECs now, we've got Washington PECs now, we've got a lot of states like Colorado, New York, Illinois that are really kind of chomping at the bit to try to get up there where California is. But California continues to be the state that has the most differences. And so we're going to get an opportunity to talk to all of y'all about some of those major differences today. And I think we've put in the Q&A the link to our ebook for 2025, which is out and now has been published. But why don't I kick us off by talking through our agenda and what we're going to be addressing with you, starting with our key wage and hour and PAGA developments, which is definitely Daniel's wheelhouse. So we're going to be talking through that. Then we'll have Christina walk you through the new laws coming out of the 2025 legislative session. We know we saw a lot of interesting developments in that regard. And then I will bring us home on the latest in employee handbook strategies and why that is a California peculiarity. We'll talk that through before we give you the CLE code and send you on your way. So with that, why don't I go ahead and hand it over to Daniel, if you wouldn't mind talking through key wage and hour and PAGA developments in California.
Thanks, Chelsea. Next slide, please. So we will be kicking this off by talking about a four-letter word that certainly applies to employers, which is PAGA. And one of the key developments that have happened over this past year is this notion of what's called a headless PAGA action. And so just providing some background in terms of what it is, and then we will dive into some of these legal developments. So it's important to note that California law has always been, according to the California Supreme Court, that there is no such thing as an individual component to a PAGA action or a PAGA claim. It is purely representative in nature, brought on behalf of the state of California. Then the US Supreme Court issued its Viking River Cruises decision, where it said that the Federal Arbitration Act preempts California law insofar as it now is recognizing that there is an individual component of a PAGA claim that can be arbitrated. But it's important to note also, this is only in the context of the FAA. In other words, when there is an arbitration agreement and an arbitration proceeding. The non-individual representative component is not subject to arbitration consistent with California law, and the US Supreme Court held that that component should remain. Now, with those two sort of overviews of what the existing law is, then this has now come to this concept of a headless POG action. Now, so what these plaintiffs' lawyers have done is to avoid arbitration entirely. They have been arguing that the plaintiff is only suing for civil penalties on behalf of other employees and not asserting an individual POGA claim, and therefore there is nothing to compel to arbitration. And only the non-individual representative component of the POGA claim should continue and therefore only remain in court. So that's the concept of a headless POGA action. Next slide, please. So what has happened is over this past year, there have been various cases that have come out recognizing or not recognizing headless POGA actions. And so there's this quick chart, and I'll go briefly into some of these cases to show the logical reasoning that the Court of Appeals have engaged in to allow headless POG actions. But you see in this chart, there are certainly more cases allowing headless POG actions than there are not. The good news or bad news, because it is the California Supreme Court, the California Supreme Court has agreed to hear this decision or resolve this issue. And I think it's safe to assume as a starting point that because it's the California Supreme Court, the decision will likely be against employers. But nevertheless, this at least sets the groundwork and gives an overview of where we are heading into the California Supreme Court decision. So I want to briefly go over some of these cases, and I think it's important just so that the reasoning of these cases makes clear how the statute seems very unambiguous in that the plaintiff has to bring a claim on behalf of both him or herself and other current or former employees. That is a direct quote from the statute. And the word "and" is deliberately used in the statute. But let's start with the CRST expedited decision. This is a quote from the decision, which shows sort of the illogical reasoning. The court said, "We recognize that 'and' usually, but not always, is interpreted as a conjunctive that means also or an additional thing. In exceptional circumstances, however, it is something fair and rational to it's sometimes fair and rational to construed and disjunctively." And so what the Court of Appeal essentially did was, okay, no matter what the statute says, even though it used the word "and," we are going to interpret the word "and" to actually mean "or." I know Christina is going to be talking about laws in the legislative session that came out and that we anticipate being enacted and going into effect in 2026, but we would expect statutes should mean what they actually are supposed to mean. Well, if that weren't enough, let's look quickly at the Galarza decision. And this decision was really quite paternalistic. So let me give you a quick quote from the Galarza decision. And this is how this Court of Appeal tried to convince us that the word "and" actually should mean the word "or." Suppose a parent said a child may have a snack of cookies or ice cream, and then changed the permission given by stating, "I misspoke. You may have a snack of cookies and ice cream." Like the legislature, the parent deliberately changed the wording of the permission given. That change by itself does not unambiguously demonstrate the parent used "and" in a strictly conjunctive sense. In our view, permission to do A and B is different from a command to do A and B, and the most likely interpretation of the parental permission given is that the child has a choice of 1, no snack, 2, cookies alone, 3, ice cream alone, or 4, both cookies and ice cream. I hope everyone is confused at this point because it just makes no sense. As a child, if my parent is telling me I can have cookies and ice cream, I'm going to be eating cookies and ice cream. I don't take that to mean, oh, I have 4 different options here, and let me try to figure out what my mom and dad are trying to say. But that gives you a gist or a feel of some of the legal gymnastics that these Court of Appeal decisions have been going through to try to justify its reasoning. So this is a key development in the law. Every employer is at risk for a POG action in California. And so I think this is a trend that we definitely need to be carefully monitoring. Next slide, please. Another key development that has happened this past year in the world of PAGA is what constitutes PAGA standing. And for those who don't live in this world, this might come as a shock, but there are Court of Appeal decisions saying that even though PAGA is subject to a 1-year statute of limitation, even if somebody suffered an injury 20 years ago and ended their employment 20 years ago, they can still bring a claim under PAGA for other employees. So that was one conclusion reached by the Osuna case. And there's another one, Maxim v. Johnson, or Johnson v. Maxim Healthcare, that also held similarly. That's an older decision. But the Williams decision that was also issued this past year held that no, the statute of limitations is 1 year. The new PAGA statute makes clear it's 1 year, and therefore, no, this is a 1-year statute of limitations. And just an important caveat, and I should have started with this, this is the question of standing under old PAGA. The new PAGA statute does make clear it's subject to a 1-year statute of limitation, and the plaintiff bringing the lawsuit had to have suffered a violation within that year. But as the Court of Appeals said in the Williams case, and this is an argument that we often make in these cases as well, the PAGA statute is just confirming what the law has always been. And so this should be further confirmation that if we have a case under old PAGA, it should be subject to a 1-year statute of limitations. Fortunately, as cases go on and as time continues to pass, the old PAGA statute will have less and less relevance, and the new PAGA statute, which makes clear it is subject to a 1-year statute of limitation for standing purposes, this issue should essentially be moot in the future. Next slide, please. Another development that has happened over this past year, and this might be of interest to at least some of you on this webinar, is the distinction being made between private and public employers. And what is interesting here is, as onerous as the laws are against employers in California, the state of California is trying to exempt themselves and public entities from these very laws. So in the Krug case, it was a reimbursement law. And there, the California State University, which is a public entity, successfully argued that they should not be subject to the requirements under 2802, Labor Code Section 2802, for reimbursement of business expenses, because the statute doesn't expressly permit or authorize lawsuits for failure to reimburse. And similarly, in the Rose v. Hobby Lobby stores case, the LWDA, which is getting the windfall of all of these PAGA actions, under old PAGA, 75% of any civil penalties recovered would go to the state, and under new PAGA, 65%. Nevertheless, when there was a judgment entered against the, in favor of the employer, against the plaintiff, and the court awarded costs, the LWDA was able to argue that because they didn't control or intervene in the action, even though they're the ones recovering or able to recover a bulk of these penalties, they should not be on the hook for any costs. So there, the state of California was also exempted from the imposition of costs in a PAGA suit, again showing the dichotomy between public and private entities. Next slide, please. Now, outside of the world of PAGA, one development that has happened is the California Supreme Court has clarified what it means to have a good faith basis or a good faith defense for any award of liquidated damages. In the Eloff case, I won't go too much into details, but it just involved a situation where the plaintiff was performing certain maintenance work on a property, and the parties, both parties, were treating that plaintiff as an independent contractor, and was providing free housing, but not any wages. The trial court and the Court of Appeal both found that no, it was not an independent contractor relationship, it was an employee relationship, and therefore wages had to have been paid for any time spent performing services. And but the trial court and the Court of Appeal were found that the employer, the defendant, had a good faith argument that that they believed, although mistakenly, that there was an independent contractor relationship and therefore liquidated damages should not be awarded. But the California Supreme Court reversed and said that no, if you want to actually have a good faith defense to avoid the award of liquidated damages, you need to have, at a minimum, look to see what the law required and make a reasonable attempt to understand that. And simply ignoring the law or having a misunderstanding, even if it's mutual by both parties, is not enough for the good faith defense. So for any companies out there using independent contractors, this is an issue that we think will continue to come up. Misclassification of independent contractors is a claim that we regularly see in litigation. Next slide, please. Another development that has happened this past year that makes California unique is California does allow waiver of meal periods. If somebody works more than 5 hours, but no more than 6, they can waive their first meal period, for instance. And that was the issue in this Bradbury case. The plaintiff in this case argued that a meal period waiver had to be done on a shift-by-shift basis. A common practice by employers in California is to have a prospective written waiver that prospectively will waive any meal periods that an employee would otherwise be entitled to if they work more than 5 hours, but no more than 6. The Court of Appeal held that the practice that employers have been following is valid. You can have a valid prospective waiver, but there are a couple of caveats. That the waiver has to be in writing and really should be signed by the employee, has to be signed by the employee, be a standalone document, make clear that the waiver is voluntary and it was signed without coercion by the employer, and also make clear that it's revocable at any time and explain how to revoke it. And in that decision, the Court of Appeal also did leave open some arguments as to how an employee might be able to argue that waivers are unconscionable. And so this is something employers should also be mindful of. For instance, the Court of Appeal specifically noted that employees might be unknowingly signing waivers, and if so, then that would be unconscionable. Or if employers are somehow coercing their employees to sign, or that the employees could not actually freely revoke the waivers despite what is stated on the face of the waiver. So those are some arguments that employers should really be on the lookout for as well. Next slide, please. And finally, I know we've been mentioning the CAMP decision in various webinars regarding wage and hour issues, but oral argument is set to occur in the early part of 2026. The CAMP decision is the one that is going to resolve, maybe once and for all, whether rounding is permitted under California law. Previously, the Supreme Court suggested for quite a while that maybe it is allowed, in other cases, no, more recently saying it's not allowed. We anticipate the decision saying that time rounding is not going to be permissible. So if there are any employers out there who are still using time rounding, one, definitely should stop the practice. But we also want to highlight that this decision should be coming out sometime in 2026. And personally, I expect the decision to be retroactive, which is something that the Supreme Court's recent decisions have been doing. So just flagging that as the last slide. And with that, I will hand it over to Christina.
All right. So thank you all for joining us for this year-end recap of everything that's peculiar in California this year and prior and beyond. We already did a legislative update at the end of this legislative session. So this is really a refresher for completeness and then a segue into Chelsea's section, which will tell you what do you do with all this? You know, what do you really need to know going into 2026 to make sure that you are as compliant as you can be with all new laws. I do also want to mention that if you have any questions about any of these bills, or want more details, we have a blog on our California Peculiarities blog, calpex.com, that has more details about some of these, and also such as the stay or pay law that I'm sure you all have been anguishing over. We have kind of a deep dive blog into that one. We also have our PAGA paraphrased blog if you really want to geek out on PAGA and know everything about it. So, like I said, here's your high-level reminder overview, and having the bills and the slides for you if you want to go back and look for them, refresher as to what went through the California legislature this year to make California even a little more peculiar than we were before. As you might know, to start with, California is one of 12 states, I believe, that has a full-time legislature. So that is part of the reason why we are so peculiar. They need to have stuff to do every year. And we have a whole lot of bills that are introduced every year and a whole lot that make it through. Governor Newsom has stayed pretty consistent on his passage and veto rate each year. We're not going to go into vetoes, of course, but the couple to keep your eye on for next year, to mention now so I don't forget about them, are AI bills. There were quite a few, and Newsom essentially said, keep trying. Also immigration-related bills and some COVID leftover bills that he vetoed as unnecessary. But I think immigration will continue to be a hot topic in California, as will the AI. So stay tuned for that as the legislature kicks off again within the next month for the 2026 year. The first two bills are bills that revised what was pretty groundbreaking legislation in California a number of years ago with significant amendments to the Equal Pay Act in California. And what they did to those laws this year in 2025 was, first of all, revised the definition of pay scale to mean a good faith estimate of the salary or hourly wage range that the employer reasonably expects to pay for the position upon hire. For those of you when the law first passed or the significant amendments first passed, you remember we were all panicked to figure out, well, what if we aren't exactly right with this range? What if you don't have a range? So we're getting a little more nuance amended into the law here, which is not a bad thing. This law also, the new law also effective January 1st, will be confirming the wages definition for equal pay claims aligns with the Federal Equal Pay Act standards, and that it includes all forms of compensation. That was another question that we so often had. Well, what do we factor into the definition of wages here? It's listed on the slide for you and listed in the statute now. Life insurance, vacation pay, holiday pay, stock options, bonuses. And there's no requirement for employers to include additional forms of compensation in the posted pay ranges. The bill also expands the statute of limitations for civil actions under this law to recover wages to 3 years after the cause of action occurs, and permits a 6-year look back period. And in not as confusing of a semantic change here as Danielle went through, it also replaces opposite sex with the term another sex in the law to acknowledge the variations that can happen in relationships here of people. So the other pay data bill that passed was SB 464. This one requires employers with 100 plus employees to collect and store any demographic information that an employer or labor contractor gathers for the purpose of submitting the required pay data report to the Civil Rights Department separately from the employee's personnel records. So Chelsea's going to talk a little bit about some additional requirements for if you get a personnel file request, but also you got to make sure that you're complying with California laws regarding where you're keeping your employment and personnel records. This bill also imposes a civil penalty against an employer who fails to file the pay data report upon the Civil Rights Department's request. And beginning January 1st, 2027, so you get a year to prepare for this one, the number of job categories on which the employer must report increases from just 10 to 23, over doubles. So clearly we don't have those all listed here because that's a big increase. So check the statute or any of our publications for more detail about that change. The next set of bills AB 250 extends the period under which we can revive claims for damages suffered due to an alleged sexual assault that would otherwise have been barred due to an expired statute of limitations prior to January 1st, 2026. It also, as is most relevant for employment purposes, it also revives derivative claims for wrongful termination and sexual harassment. The catch to this is to get this extension, the plaintiff has to demonstrate that one or more entities legally responsible for damages engaged in a cover-up, and cover-up is defined in the statute. And again, you got to look at the dates here to make sure that you actually are eligible for this. The claims have to already be pending in court on January 1st, 2026, or if commenced between 2026 and December 31, 2027. So a limited period of time. SB 303 was actually something intended to help employers out and help people out trying to do the right thing. It states that an employee's assessment, testing, admission, or acknowledgement of their own personal bias that is made in good faith, that is also not solicited or required as part of bias mitigation training, does not constitute unlawful discrimination under the FEHA. We want people to be able to acknowledge that we all have some inherent biases and to learn from them as part of this. The next set of bills, or the next single bill on this slide, is one that Chelsea's going to speak about a little bit. So I'm going to pass right by it and leave it as a placeholder for you if you want to look back at some of the details. On the next slide, we also have one that's going to be even more important for handbook purposes and for leave of absence purposes. So Chelsea's going to tell you the practical implications of the designated person. What she's not going to talk as much about, because I don't blame her, and this is almost a subspecialty, is Cal WARN. You know, California can't just use the federal WARN Act. It has to have its own mini WARN, as you all know, if you've ever had to deal with some sort of mass layoff. And what the legislature did this year to Cal WARN is it amended it to require some additional things be included in employers' Cal WARN notices. Number one, whether the employer plans to coordinate services through the local workforce development board or another entity, or not at all. And to provide information about CalFresh, which is a statewide food assistance program. It's got some other stuff in there. So if you're in a Cal WARN situation, make sure you look at the amendments to the statute by this bill, but they were a little too minutiae for us to spend time listing here. The other bill we have on this slide is, also kind of a hiring and firing sort of bill, and this is also a COVID leftover. This bill extends certain hospitality employees' rights to rehire after being laid off for COVID-related reasons. It was from December 31st, 2025, but now it will also be extended through January 1st, 2027. So we've got another year past this coming year. Here we have listed the industries to which it applies. If you're in one of these industries, you're already well acquainted with this law. So essentially, you just need to know that it has been extended another year. Next, we have a little wage hour stuff, which is Daniel's specialty. We just know enough to be dangerous and tell you who to go speak with if you have detailed questions. But we do know that now, as of January 1st, 2026, the Labor Commissioner will be authorized to investigate and issue citations or to file a civil action for any gratuities or tips taken or withheld by an employer. Obviously, you don't want to take employees' tips. We've known that, but now the Labor Commissioner is expressly authorized to come after employers that do that. SB 261 will subject employers who don't satisfy wage awards toward them within 180 days to specific measures, including the Labor Commissioner posting the unsatisfied award against the employer on its website, so a little public shaming there, imposing a civil penalty on the employer of not more than 3 times the outstanding judgment, and there can be enforcement of the payment of the judgment to recover attorney's fees and costs. I know none of you get yourself in this sort of situation, but just be aware that if you know anyone who does, these are the sort of consequences that they could face. Next, Bill. All right, here's the biggie, but we want to get to the more interesting big picture. So again, I'm not going to go into detail. Like I said, we have a very detailed blog we wrote on this. And if you're dealing with this, you probably already are in the weeds. If you're not dealing with this, but you have any sort of employment contract that provides bonuses, that provides training bonuses that must be repaid. For example, if somebody doesn't stay, training provisions where there's repayment required if somebody doesn't stay for a certain amount of time, relocation assistance, any of those sorts of things, you need to be looking at this new law right now and making sure that your contracts for these repayment provisions and for these what are otherwise benefits comply with the provisions of this new California law. California is very actually unique in this area. We are the first state to have what they would call anti-trap or have called anti-trap law that is this robust. New York has had one pending on the governor's desk for a while. Colorado has one. Some other states have them that are either limited to certain industries or are just generally more limited than California's law. So it's really important to take a look at what you do and take a look at this law. And again, if you have any questions, we've been looking at this from every single angle to figure out how to continue to offer what usually are great benefits for employees without running afoul of this law. For those of you who are not familiar with this law, the very high level overview of what it does is it makes void, says these aren't valid, employment contracts that are entered into on or after January 1st, 2026. So if you already have the contract now, there is a school of thought that says, don't change it, just let it ride. But know that if you enter into something new after the new year, then you need to comply with these new provisions. So those contracts that require an employer to repay a debt to the employer or certain agents of the employer, if the worker's employment or work relationship terminates, those contracts are void. There are certain exceptions to this. Tuition payments, discretionary bonuses, relocation payments, if certain, very certain requirements are met. That includes the repayment terms being in a separate agreement from the primary employment contract. The worker gives time to think about it, to consult an attorney before signing it. The repayment obligation for early separation must be prorated based on the remaining retention period and cannot accrue interest. And again, a couple of other requirements that apply here without going through each of them in detail, but please know that depending on what sort of benefit it is and what the repayment obligation is, different provisions of this new law could apply. So really stay close to the provisions of the law to make sure you're fitting within any of these exceptions and the criteria that need to be complied with for these exceptions to apply. If you violate this law, then you could be liable for actual damages or up to $5,000 in penalties per worker, as well as injunctive relief and attorney's fees and costs. This is yet another attempt by the state of California to say, we really don't want employers doing anything at all that could restrict employee mobility and restrict the ability of an employee to, if they don't like a job, to pick up and go to another job. But again, some would say that maybe it goes a little bit too far in that it may cause employers to not offer some of the benefits that employees really want. Next slide, please. The Workplace Know Your Rights Act, in what wins the clunkiest act title of the year award, this bill really talks about a written notice that employers must give employees. So starting on or before February 1st of the coming year and every year after, at the time of hire, employers must provide a standalone written notice to employees describing certain workers' rights. Luckily, The labor commissioner is charged in this new law to develop a template notice that you can use for this. Some years the labor commissioner seems to make that deadline whenever the legislature imposes a requirement like this. Other years we're waiting and waiting and waiting, usually when it's the biggest deal sort of notice you have to provide. But here, sadly, it means you also have to give employees yet another notice. I mean, flashback to the wage theft notices. So just have this on your radar, please. Also, by March 30th, 2026, employees must have the opportunity to identify an emergency contact who their employer must notify if the employee is detained at work or if offsite during work hours, if the employee has actual knowledge of this happening. And a CBA can cause this provision to be waived if it is clear and unambiguous. I think most employers already allow this anyway. For violating this new Workplace Know Your Rights Act, you could be subject to $500 per employee per violation. Next one, please. And wage garnishment. Not the most interesting topic, but please know that if you are in a wage garnishment situation, then the return that the employer has to provide to a levying officer has to include the following information effective January 1st, 2026. The date the employer provided the judgment debtor with the earnings withholding order, the notice of earnings withholding order, the name and the title of the person who provided the order and notice, and a description of the manner in which the order and notice were provided. If you deal with these, you know what this is all about. If you don't, now you know. On to the next one, please. Okay, personnel records. Chelsea's going to be all over this, so just flag this for your records if you want to go back and figure out which bill was it that made that change to personnel records. It's here. Civil discovery. This is an area that not just by our legislation, but also in the way California courts work is highly peculiar. Every single court in California and every single judge in California seems to have different rules and requirements. And I mean, these days, regionally as well, we're seeing huge verdicts coming out of Southern California that might not happen elsewhere in the state. So this is a state where you really need to know where you are, but at least statewide in the Code of Civil Procedure, SB 66 removes the January 1st, 2027 sunset date from initial disclosure requirements in civil actions. So now that requirement is going to be permanent. Prior to the imposition of this requirement, it was really just federal courts where you had to make initial disclosures, but now California courts, state courts require it as well. And to close out our last three, these are all industry-specific laws that Chelsea's going to touch on a bit. So again, I'm just going to flag these three for you as if you're curious, again, which bill was it that made these changes? You can come back to these slides. So we'll flip through this slide, the next slide, please, and the one after that. Brings us to handbooks. Chelsea.
Thank you. And thank you both. I always love doing these webinars because it gives me an opportunity to hear some of the things that my very esteemed colleagues are also working on that I know very little about. So it's a wonderful way for us to all be kept abreast on what's new and notable. I do want to pivot to the latest on handbook strategies because a lot of the new laws and what we have to pay attention to in California, we have to turn it somehow into something practical that employers can use. And a lot of these have to do with the way in which we shape our workspaces, the way in which we treat our employees, some of the entitlements that they are eligible for. And so I always think it's a good idea to talk a little bit about handbooks when we're talking about what makes California unique, because in addition to everything else that we've already told you about today, California just has a host of laws that actually require that you have certain policies on certain things. And so why don't we start by talking through, just as a refresh, since we are in the middle of handbook season right now, why even have a handbook in the first place before we dive into a lot of the specifics on California's peculiar nuances in this space? We know that a handbook is a really good opportunity for us to be able to identify expectations for an employee, communicate those expectations, brag about our benefits, give employees a really good framework and introduction for what they're going to expect when they are our employees. And, aside from having a bunch of different places where an employee might have to dig up this information, having a handbook is a good way to have it in one central repository. Now, that doesn't mean we need to publish something in writing and dust it off every day and have something that employees could actually put in their hands to read. Most of our employers, at this point, use an online system or an intranet for their handbook or their policies, and it's going to be a good place for employees to be able to access resources and get that information, as well as receive notice of legal rights and obligations like at will, and even policies on confidentiality and arbitration, which we would also recommend be in separate agreements. And so this is a really good place to start, lays the foundation for everything when an employee is going to walk in the door. And this is going to be our guidepost for everything. And on the next slide, because I always get questions on why do I need a policy on a particular thing, these sort of fall into a couple of categories, and several of these are specifically important in California, which we're going to get to in a moment. But believe it or not, there are a few laws across the country, not as many as you'd probably expect, but a few laws that actually have language in the law that says you have to have a written policy on this, and it has to be distributed to all of your employees, and here are the things that need to be included in this policy in order for you to be compliant. And like I mentioned, you don't really see that in a lot of laws, but you do in a number that we're going to go over in just a couple of moments, especially in California. And so obviously, number one, why do I need a written policy? Because the law says you actually have to. But it's a larger category. My second bullet here are our recommended best practice policies. And I'll go over a little bit of a California list of those in just a moment. But ultimately, not having a policy in certain areas makes it very difficult for a Daniel or a Christina to defend you if you end up in a case about a lot of the topics that are going to fall in my second bullet. And so when I have clients, and they often will come and say, oh, all I want is the absolute must have, required by law, only when a law says I have to, and I will stop them and ask them to pause and say, there's a whole category of policies that if I didn't recommend them to you and I didn't just really fight tooth and nail for you to include them, you could get yourself into a lot of trouble, and it's going to be much more difficult for you to be able to defend yourself in case of a claim. And so that's going to be probably the largest grouping of these policies, and that's especially true in California. Obviously, our number 3 bullet, if there's a new practice that you want to roll out, or a different practice, let's say you've been offering vacation in a particular way and now you want to change that, having a policy on that is a great way to be able to introduce it to your employees and socialize it. And that's especially true, like to Christina's point, there's a host of new laws that have come through even over the last couple of years, that the best way to introduce that concept or that difference to your employees is to roll out a policy on it. Even if ultimately it's not something that would fall into our first 2 bullets, having that third category of I want to introduce something, I want to show that there's a change, or I want to roll out something that we weren't offering before. Number 3, our bullet is going to be that category. And our number 4, I like to call our worst case scenario category. Let's say you weren't following a law, or something went wrong, or there's something that you're identifying that has been a consistent problem over and over and over again. Having a policy to sort of right the ship or introduce a concept that we thought was clear but maybe wasn't as clear is a great way to utilize our policies for that. So we've got these 4 categories, and those, like I said, those first 2 are going to be especially important for California. So let's go to our next slide, and we can talk just a little bit about the concept in California. There are a number of statutes that are actually going to require a written policy, and we're going to go through each of these. As you may be aware, because this is not new, California is one of only a few jurisdictions that actually requires requires you to have an EEO harassment, anti-retaliation type of policy. And within the last decade, we've obviously seen a number of developments in this space where the regulations outline a very specific list. It's not just that you have to have a policy and then wing it. It's a very specific list of what needs to be included for your harassment policy to meet these requirements. Things like, for example, laying out all of the particular protected categories under California law, which, as many of you know, is a much broader list than what we find under our federal laws. And so one of the things that you have to do is outline every single one of those protected categories. You also have to help the employee navigate the reporting requirements by identifying an individual, not necessarily by name, but by title, who is the designated point person for purposes of your harassment complaints and your concerns that are being raised. Other things that are notable that need to be included in a harassment policy in California for it to be considered compliant and best practices. We want to include limitations on confidentiality, the idea that we don't guarantee complete confidentiality with these concerns, which is obviously the case because we need to be able to do a thorough investigation, or putting in writing that we don't require employees to actually raise these concerns to their direct supervisor. These are all things that you may not have in a run-of-the-mill EEO policy, but California law is going to require they exist in a California compliant EEO and harassment policy. And one of the things, because as you probably are aware, the laws are changed. I mean, for example, the DFEH went to the CRD without much splash, and people just sort of one day woke up and it was named a different agency. But they sometimes make new regulations and have new information without any ceremony. And so there was a new regulation that came through just a few years ago that added some requirements that need to be in your EEO policy, including a link to the CRD's website on harassment training and prevention. That's actually required to be in your policy. And it's not something that a lot of people would even know to include there unless they spend an enormous amount of time digging through the regulations like I do. So just to keep in mind that, again, a requirement under the law, there are a few other states that do that, but the California list is going to be incredibly particular in this regard. Other areas where we have requirements around policies, the California Family Rights Act and the California Pregnancy Disability Leave Law, essentially saying that if you provide any policies to employees, these must be included in your policies. And generally, a lot of our clients are going to have FMLA policies already. And so having a CIFRA policy and a PDL policy on top of that just makes logical sense because it's going to head off a lot of the questions if those policies didn't exist. But some of the things that need to be included in these policies to make sure that our employees understand their rights, their responsibilities, whether they're going to be required to use their vacation and sick time to the extent they're allowed to be required under these types of laws. There is a long list of things that we want to make sure that our employees are aware of about both of these laws. And for those of y'all who may not be as intimately familiar with CIFRA, it is the California counterpart to FMLA, but it applies to a smaller employer and provides significantly broader reasons why an employee would want to take time off or be able to take time off. And the California Pregnancy Disability Leave Law, a completely separate entitlement for an individual who is disabled by pregnancy, childbirth, or related medical conditions to take up to 4 months of job and benefit protected time off when they are impacted by that disability. And these are things that, again, you have to, because the law says so, you have to have a policy on this space. And so having those play as a little bit of a counterpoint to FMLA, or if you're smaller and FMLA doesn't apply to you, having some of the details around CIFRA and PDL is going to be a very necessary element in your policies or your handbook offering. Another area that is a required California law, and this one is not that old, within the last several years, a lactation accommodation policy. As you know, California has been on the forefront in lactation accommodation for many years, and we've we've always had much broader, much more employee protective laws in this space. But in the last few years, we expanded our lactation accommodation law and included a written policy requirement where, again, not only do you have to have a policy, but you have to outline things like how someone requests an accommodation, what the lactation accommodation room is going to be like. It also has to include information about anti-retaliation, and if an employee wants to raise a concern, to whom they raise that concern outside of the organization. So, for example, knowing that the CRD or the the DLSE could be addressing some of the complaints in this area, and so recognizing that these lactation accommodation policies are very specific to California, and this is an area where, because the law says we have to, not only just because it's the right thing to do, there is a requirement to have a policy in this space. For those of y'all who might be outside of California and thinking about the Pump Act, for example, Pump Act came a little bit later and really does marry itself pretty well to the California law. They're very similar, but that lactation accommodation policy requirement is a California specific requirement. I also included on this slide the note that several local ordinance requirements do apply, that there are some laws, for example, in the city of San Francisco where I am, that are going to mandate that an employer have a policy, for example, on its own lactation accommodation. It's totally possible to fold some of that into a California specific policy as well, but there are just going to be a couple of things that apply under some of these laws, that at the local level that will add to your list of statutorily required policies if you're a California employer and you happen to have operations in city of San Francisco or some of the other local jurisdictions that abide by this. On the next slide, I want to talk through some of the other California policies that go in my Chelsea's Perfect World, CPW list of strongly recommended. I would be totally remiss if I did not recommend these types of policies in California, because the laws in California are just so difficult. And I know, Daniel and Christina appreciate that when I am recommending to employers what policies that they have, a lot of these are around the wage and hour space, because we see so much wage and hour litigation in California. And so I think personally, and I think Daniel and Christina would agree, it's very difficult for an employer to defend themselves in a wage and hour class action related to meal and rest breaks if an employer does not have a meal and rest break policy at all, or they do not have a California specific and compliant meal and rest break policy. And so one of the areas where, we still decades later see a lot of activity from a litigation perspective is on meal and rest periods. And so we like to have a really robust policy and recommend that such a policy is there to be used both as a shield and a sword in the meal and rest break space, communicating to employees what the requirements are, what we're expecting of them, what happens if we are not necessarily compliant, if an employee misses a break, or how we're going to handle things like attestations if they're being used, or automatic payment of premiums if they're being used. And a good meal and rest break policy in California, my template, for example, is a little bit over a page long, because it really does get into the detail to make it very difficult for an employee to later argue, well, I didn't know I was supposed to get meal and rest periods. Well, yeah, you did. It's right here and it's right there and you signed off on it. So we've got a really good position of defense to be able to show all of the things that we were expecting to do, what the reporting structure would be if they miss a break, for example. And similarly, because California overtime rules are so different, it's always a good practice to have a policy on overtime and what the California overtime rules are. I very often will pick up a federal handbook or a handbook that's supposed to be national, and I will see a great call out about 40-hour-a-week overtime, but totally missing those California requirements. And because we've got daily overtime, it is not uncommon for a national employer to not realize that these requirements are so specific, and there are so few exceptions to the policy that outlining that in a policy is always going to be a recommended best practice. Timekeeping, similarly, we know we have to have time records in California. Having a timekeeping policy that prohibits off the clock is a great tool as well, and really good to be able to help defend from an off the clock claim. Reimbursement, as you know, California is one of the only states that requires reimbursement for all reasonable and necessary business expenses. And so having a policy that outlines all expectations in that space and how we're going to navigate that is going to be a best practice there as well. Paid sick leave and vacation, we also have to realize are very nuanced for California, and having a policy that's going to very specifically outline exactly what it is we do, how we comply with the paid sick leave laws and the vacation laws in California to put us in our best possible legal position if there's a claim in that space. On the next slide, I want to talk through some of the areas over the last several years that we've seen recent developments. This is not to 2026, but over the last few years, some of the major things that have created a need to update handbook policies in California. California is one of the only states that has a mandatory bereavement leave that came a couple of years ago, and layered on top of that, there's also a reproductive loss leave element to that. And so although neither of these leaves actually has a written policy requirement, because bereavement leave policies are so common, we strongly recommend ensuring that your bereavement leave policies acknowledge the requirements of California law and outline what those requirements are going to be. We've also, within the last several years, seen a pretty dramatic expansion of California sick leave. California, although it was first to market or one of first to market when it came to a statewide sick leave, it was relatively low on in terms of generosity, and came up to meet some of its counterparts within the last couple of years, increasing the paid sick leave element to that, and also recognizing that there are several jurisdictions in California that have been kind of chasing their own notoriety in this space. There's a lot of local laws that are going to be more generous than the state law, but when the state law changed, it caused many of the local ordinances to need policy adjustments, because on some levels the state law became a little bit more generous. And so that's something where if you have not updated your sick leave policy in a number of years, you might be a little bit behind in terms of the generosity of your offering. And so we recommend taking a look at that as well. We also, over the last decade, really have seen a lot of expansion in terms of SIFRA, as well as the add of additional covered family members for paid sick leave. And so we're really looking at, and this dovetails really nicely into some of the things we're going to talk about that are new or on the forefront for the upcoming years, is this idea of designated person. The idea that the California legislature acknowledges that not everybody's family looks the same, and some people might have people in their lives who are better than their own families that they want to be able to care for just the same as they would an actual blood related family member. And so we saw within the last few years SIFRA expand to include this concept. We saw California sick time expand to include this concept. And so although you are allowed to limit designation to once a year, we do have that concept in sick time and in SIFRA. So let's go through a couple of the California new laws for 2026 and beyond that are handbook adjacent, right? Starting with, we know we had another expansion to paid sick that's going to allow employees to use paid sick to attend judicial proceedings when there are victims of a certain crime. And this definition of certain crimes has been expanded year over year in the last several years. And this new reason for leave is also covered under California's unpaid job protected leave and accommodation laws. What we've been doing largely is using this as an opportunity to expand and kind of work on all of our kind of domestic violence protections in California, victims of crime, and make them all into one policy that tackles all of this reasons for use. And so if you have a policy that tackles all of those things, we do recommend this is a great opportunity to mesh them all together, because they do work nicely, much better together than they did in the past. And so we have the ability to do that. And further to designated person, recognizing that that will become part of the California paid family leave structure as of July 1st, 2028 as well. That's the same definition that we're seeing in SIFRA and under paid sick as well. On our next slide, just touching very briefly on personnel records, as Christina mentioned, we now have an expansion that these records include education and training. And this is relevant for handbooks because a lot of folks have a policy related to the request for personnel records. And now that we've got this expansion, just making sure that your policy is going to include these new records that are allowed to be reviewed. And then on the next slide, a couple of additional industry-specific laws that if you are a water corporation or a petroleum facility, recognizing that your meal and rest break policies are going to need to be changed. They're going to need to look a little bit different because we've gotten some changes in this space. And obviously looking at this piece here, if you've got construction trucking or commercial motor vehicles where the driver is going to own that truck or tractor, et cetera, your expense reimbursement policies are going to need a little spruce up or an update. And so obviously we're happy to be able to do that. I want to go ahead and give you all the CLE attendance form as well. There's a QR code for you to scan. And for those of you who can't see the presentation, the verification code is SS as in Seyfarth Shaw 3003. That's SS Seyfarth Shaw at 3003. And with that, thank you so much for being willing to spend a little chunk of your day with us. Please feel free to reach out to Christina, Daniel, or myself if you have any questions on how California is different and how it applies to your policies and the inner machinations of your business. We're happy to assist with any of that.